So just perfectly on time. We'll have a very interesting and very diverse session between tort law and lawyers doing torts, almost, if I can paraphrase Emmanuel's very interesting contribution in that way. So we'll have three presentations, three people presenting. I propose we just stick to the order as it is on the program. Each of you will have 20 minutes. Emmanuel, due to the special circumstances, he'll be giving a distant automatic presentation. We'll see how that works. But the idea is that after 1 hour, we'll be finished with the presentations, more or less, and then we'll have another half an hour to discuss amongst us the different concepts, ideas, and thoughts that we will have developed. I would like to start right away and give the floor to Livio Corselli, who is a PhD candidate at the Department of Political Science and International Relations at University of Palermo. He's dealing in his PhD with law and new technologies in a comparative perspective. So as we just discussed before informally, a very up-to-date topic. And I'm looking forward to hearing your thoughts. Please, the floor is yours.
Thank you very much. Just a moment, because I will try to share my PowerPoint presentation with you. So let me see if everything works. Just a moment. Okay, can you see a full screen presentation? Okay,
perfect.
fine. Yes. Okay. So let me start with my greetings and appreciation with regards to this beautiful conference, which opens me a lot of chance of reflection and thoughts about a lot of different fields. But today we are talking about liability for sophisticated robots in a lights and shadow perspective. I mean, let's start from the boundaries. So everyone knows that robots already exist between us from more than 40 years. Actually, the third industrial revolution is characterized by the use of microchips and the automation of machines. So this is not something new. What is new is that there is a leap between the third and the fourth industrial revolution, characterized by an implementation of autonomous functions in a physical machine. This kind of machines were called by some scholars, for instance, Professor Hubbard, Patrick Hubbard, sophisticated robots. The existence of this kind of machines adds a piece in the debate regarding the nature of artificial intelligence. I mean, since the technology research seems oriented towards the creation of self-growing machines, probably this is something that can lead us to think that strong AI, I mean artificial intelligence, is the right idea, and weak AI is something that we can go over and over. I mean, several studies were enacted about robotics and artificial intelligence during the last years. One of that is, for example, the McKinsey Global Institute study from 2013, which enlightened big changes in the society and described this kind of technologies as disruptive. In a sense that they are able to make changes in labor markets,
che ci sono nel portafoglio,
people habits, and stuff like that. Okay, so there are also different studies more interested rather on social and economical implication. And the goal of this study, for instance, there is this study came from the Stanford Research Lab. The goal is to ensure that artificial intelligence will create a value for the society rather than only risk. So, but there is a main problem, and this problem regards definitions. For time reasons, I don't want to spend so much time on this, even if it's a relevant topic. It is sufficient to mention that as the tech becomes disruptive, as already said, it's harder to find good definition. And in fact, there is not a general consent on the terms robots and artificial intelligence, and each scholar gives his own definition depending on the purposes and the scope of his researches. So finally, there are a plurality of working definition, and most of the time, scholars tend to distinguish robotics and artificial intelligence as two different entities. This is the vision of the European Commission, as you can see on the left. The center of the idea is the artificial intelligence, and robotics is posed on the between, I mean, artificial intelligence and mechanics and other branch of science on the other side. So what is clear is, however, that the distance between robotics and automated software is now reducing. And that's why I tend to consider together robotics and artificial intelligence as a unique element that I love to call it robotic technologies. What I am trying to say is finally that robotic technologies are composed by robotics and artificial intelligence because of these autonomy functions. So finally, does not matter the traditional distinction between robotics and artificial intelligence on the element of the embodiment, because somebody says that if there is the embodiment, we are talking about robot. If there is not, we are talking about artificial intelligence. I tend to prefer the idea of Professor Balkin, which enlightened that robotic technologies are composed by different devices, each of them characterized by autonomy. So finally, robotics falls and artificial intelligence falls both under the robotic technologies due to the autonomy characteristic. Let's move over and explain why I focus my attention on liability. Well, to be completely honest, it's clear that liability is a matter that is able to bring big changes and concrete changes to societies. The introduction of new technologies carries out disruptive effects, as already said. And so this disruptive effect, of new tech could consist in a rise of new chances of damages. So we have to address this kind of new possibilities of damages. To react to this, legislation must be enacted and built in a way able to ensure a sufficient degree of certainty about legal consequence to each every actor involved in production, selling, and using of robotic technologies are exposed. In this sense, obviously, liability could be considered as a litmus test of social tendencies. I mean, every choice on liability will affect the development of robotic technologies. And so rules on liability could be set limits, even hard limits, making no more convenient, for instance, to proceed in commercial exploitation of robotic devices, and vice versa at the same time. And this represents a tool, as already said, able to affect innovation. So now we are, I think, ready to appreciate some dark aspects of robotic technologies, intended as elements that requires more investigation, more in-depth analysis. I want to start from the human control degree, because every machine has a different degree of control, different degree of autonomy, I would say. And the greater will be the human control over the machine, and less problematic will be to bear responsibility for damages. In other cases, when the human control is irrelevant and so the machine is have more autonomy aspects, there is a greater degree of autonomy, and so this can affect the foreseeability of machine behaviors. Okay, that's the center point, because machine behaviors are the results of data feeding and processing. So finally, data are a sort of soul, let me say, of the machine, and eventually bias in data are gonna reflect themselves in bad actions by the robot themselves. So this is another dark aspect we need to address and we need to consider. Moreover, we cannot know anything about the on how the machine process the data. And this means that this kind of what we could say machine thought are finally inaccessible, and we cannot know anything about the process followed by the machine to achieve a given result. Finally, I just want to mention that another big problem in the field of liability regarding robots as a product is the fact that robots and robotics technologies may undergo unpredictable transformation during the life, the operational life, and probably law should be follow these changes, but I still don't know if it's a possible task or not. So these are some dark aspects. Moving on, it must be noted that European Union is on the debate from more than 10 years. They just start to go deeper in the matter with the RoboLaw project in 2012. Was a study of 2 years, which inaugurates this case-by-case approach. What I mean that the European Parliament, which give the RoboLaw project the start, focused on robotics more than artificial intelligence, and launched this program and this project to identify several different categories of robots, each one with these issues on, ethical, economical, and legal implications. So this is the first kind of general study about robotics in the European Union. This study was followed in 2017 by a resolution of the European Parliament containing civil norms on robotics. And this kind of piece of legislation is actually more focused on ethical issues rather than legal issues, but actually has the merit to highlight the idea of the risk assessment approach to liability for robotics, which is something that I will explain briefly later. On the other side, the European Commission, with its parallel study, focused instead on artificial intelligence. And the main idea of the expert group that was nominated by the Commission were to address liability using the tools that we already have. And I mean, in the sense, the false liability principle, which are the main principle in tort-use liability in each member states, and a kind of strict liability framework which already exists at European level with the Product Liability Directive. So this is kind of a framework. And the last contribution from the European Union is the white paper and the proposal for regulation on artificial intelligence. The main element of this proposal is to distinguish between high risk and low risk artificial intelligence devices. To establish a division and to understand how to regulate liability for this kind of low risk and so false liability, and high risk that fall under more under strict liability. So these are the findings and solutions enlightened by European Union. As already said, the expert group on liability enlightened the existence of different liability regimes, and they recognize that full liability criteria are the main regime to attribute liability. I want to come back to the distinction between high risk and low risk AI application, which is highly recommended by the European Union. But again, well, it's easy to say that strict liability must be applied to high risk artificial intelligence devices, but how to make a real distinction between these two kinds of categorization? What are, in other words, the necessary requirements to declare a technologies as high risk or low risk? It's something that must be clarified. What is clear, however, is that the risk evaluation approach must be followed by an adequate insurance system. And this is adequately enlightened by the proposal of regulation, as occurs with, for example, the vehicular traffic. Last mention is regarding the Centralized Agency on Robotics and Artificial Intelligence, because the Commission strongly suggests to establish a kind of agency, a centralized agency, which would be useful to give a repository of experts. But however, in US, some scholars already criticized this idea. For instance, Professor Ryan Cowler from the University of Washington used to say that imagine if the Wright brothers needed to deal with the FAA to take the first flight. Probably they never lift up. So this is something to address. Okay, just to mention a brief and comparative perspective, looking to the US experience, because the greatest number of cases concerned the industrial robots historically in the US, and as you already know, comparative law is an effective tool to better understand dynamics, and so I centered my attention on these cases. What is it worth mention to say that in negligence and strict liability, which are the traditional tools used to attribute responsibility in common law, actually are used even if the industrial robots are not characterized by strong autonomy, as I already mentioned. And another interesting thing is that if duty of care could be detected, the doors opens for false liability. This comes clear from the autopilot litigations, which are an early example of application of fault liability to autonomous machines, because sometimes it's easy to find a duty of care on the pilot, and this is sufficient to bear responsibility to this subject. In other cases, however, strict liability helps victim to find a right compensation, eliminating the need of proving fault. So there is an enlightening of the burden of proof, even if the victims must still prove the defects. Okay, so I'm going to conclusion now. Just a moment, please. Okay, so reaching the conclusion, it must be said that the goal of liability finally is to find a balance between innovation and compensation of victims. In other words, between the benefits carried out by new technologies, and we all are just we all know the huge benefits that technologies can carry out, as in the instance of the Zoom webinars, for example. But this must be balanced with the risk that new technology may pose. So we need to keep improving innovations, ensuring that victims will be compensated in case of damages. And this to avoid liability gaps. I always mention the Japanese example because they enacted the legislation in 2006, and this legislation was inspired by Asimov law. But as you already know, Asimov laws are a little bit narrow because are centered on the idea that robotics must not be damaged to human beings. And so Japanese, as a result, prevent the industries to be competitive, for instance, in the field of medical robots. That's why the Da Vinci robot is more advanced than the Japanese robots. And that's why Japanese has launched some reforms in 2015 to deregulate and to open the matter. So probably scientific progress will lead us to rethink traditional categories, but my thought is that probably is not the time, because we are not in front of fully autonomous devices, and so there will be a point in the future probably, but it's not now. What is clear is finally that liability is a work in progress, especially in the field of new robotic technologies, and regulation of robotics is no more a theoretical effort. So thank you very much, and excuse me.
Thank you very much for this very interesting overview of the current state of regulation and the issues. And too bad you didn't have well, congratulations that you stick to your time, but too bad that you didn't have more time to expand on the comparative reflections. I hope we'll have time in the discussion to get back on that part. Now I would like to change the topic and give the floor to Emmanuel Didier. I will have to put on his PowerPoint show, and you will see that he has prepared a presentation where he will be speaking automatically. I just need to have it going first, so just give me a minute to get it going. Here we go. And now I have to face the challenge of being the person behind the machine that you mentioned before.
Yes, you have to be careful because you are in control.
Did it stop? I have to. Okay, let's go again.
Lucas, would you like me to
Yes.
do it from my point of view? Because there's no voice.
You don't hear the voice. Ah.
Yeah, that's one of the challenges of the new technology. I'm not.
Exactly.
Well, sometimes machines are stupid more than intelligent.
Or it's the human beings behind that don't know how to manipulate.
No, machines, just machines.
I think there is a function to share sound on your side, Lucas. So there should be a function to share sound.
Share sound as well.
I remember I needed to do this for one of courses when I wanted to show video to my students. So let me see if I can find this function or just Google it.
I didn't find it here.
Do you want me to present it from my
Yeah, please try.
perspective?
Yeah.
Okay.
I think it makes much more sense.
More. Invite.
I look it up.
Share screen. Okay. Can you see the devil's advocates? Okay, we're gonna start from beginning. Oh God. Can you hear?
Yes.
We can hear your voice, but not the recording.
Same thing. Whoever shares the slide must share the sound as well. So you just check. I've just sent you the link. How to share the sound of something which is already recorded.
Okay.
Select share sound in the bottom left corner of the share selection window. Uh-huh. Yeah, I think I've found the solution. Thank you. I just need to get the PowerPoint going again.
So that you know, the whole thing is on academia.edu. So if you will see it the way you want. The reason why I'm doing it is that I'm expecting a phone call from the hospital where my father has been hospitalized yesterday. I didn't want to cut the our meeting, but it looks like there's still a lot to be done, to be understood. Okay. Can you see it?
Yes.
Okay.
The Devil's Advocates, the enforcers of judicial terror, Fouquier,
Can you hear it?
Wyszynski, and
Not yet.
Freisler.
So I think you need to start sharing again. And while you choose share screen, there is also an option to share sound.
Yeah, I saw the option and I clicked the option.
Okay. Could you start it over?
Let's try again. It even shows that it should share the sound.
Okay, so could you share the presentation with me? Maybe
Three
I
different
could
destinies.
try.
One beheaded, the second killed by a heart attack or poisoned, and the third killed by a bomb. But an astonishingly
Hear
similar
anything?
common path.
Not yet.
Judicial enforcers of pitiless and genocidal dictatorships. Born in the bourgeoisie, trained as lawyers, political opponents of the old regime who joined the victorious patron in order to eliminate the old
Now?
elites and the present opposition
Not
to
yet.
establish a new legal order. They began as enforcers but quickly became architects of tyranny by the earthquake and the realignment in France from 1789 to 92. It's the fall of the monarchy.
So because the file is too big to be shared,
Oh,
you would have to download it.
Can you, I'm going to try.
The Devil's Advocates, the enforcers of judicial terror, Fouquier-Tinville,
You hear it now?
Wyszynski, and Freisler.
yes.
Can you see it also?
Introduction,
Okay.
Yeah, it
Auspicious
works.
beginnings, the earthquake and the realignment, instruments of judicial terror, the end, justice delayed, justice denied, and conclusion. Three different destinies. One beheaded, the second killed by a heart attack or poisoned, and the third killed by a bomb. But an astonishingly similar common path. Judicial enforcers of pitiless and genocidal dictatorships. Born in the bourgeoisie, trained as lawyers, political opponents of the old regime who joined the victorious patron in order to eliminate the old elites and the present opposition and to establish a new legal order. They began as enforcers but quickly became architects of tyranny by making themselves indispensable to their patron, thanks to deep knowledge of the judicial system, enormous work capacity, mastery of language, commitment to the powers in existence, and crushing personal ambitions. They wrote extensively pleadings, judgments, laws, regulations, treatises, and courses, justifying, orienting, and routing legally the dictatorships. Dictatorships which use 8 basic tools in order to tame the judiciary: exceptional laws, competition between the judiciary and political police, purging of the courts, court packing, limitation of jurisdictions, creation of special jurisdictions, persuasion and conditioning of legal minds. Fouquier-Tinville, Wyszynski, and Freisler acted with the 8 tools as enforcers in the special courts and as organizers of mass murders conducted by the state, a phenomenon which is not limited in time or geographically, as we can see now in Afghanistan, Iraq, Iran, and ISIS. Inauspicious beginnings. Fouquier-Tinville, a bankrupt member of the nobility of Robe, was born in a noble family in 1746. He becomes a lawyer with a good practice, but must abandon it because of gaming debts. In 1789, he participates in the siege of the Bastille, and is a cousin of Desmoulins who introduces him into the political circles, and whom he betrays in 1792. Wyszynski, a rebellious child of the bourgeoisie, was born in Russia into a Polish Catholic family in 1883. As a law student, he becomes a Menshevik. He might have been a double agent working for Kran as a provocateur. He murders police collaborators. He's imprisoned in 1908 with Stalin, and he becomes a lawyer in Moscow courts. Freisler, the son of a bourgeois family, was born in Celle in 1893. In 1914, he enlists, is wounded in action and decorated for heroism. He's sent to the Eastern Front, taken prisoner by the Russians, and remains until 1920 as a prisoner camp, where he might have been interested in communism. Back in Germany, he studies law and becomes a lawyer in 1924. Then he becomes a representative of a right-wing political party in his municipal council. The earthquake and the realignment in France from 1789 to 92, it's the fall of a monarchy and the establishment of a republic. In March 1793, it's the creation of the Revolutionary Tribunal, of which Fouquier-Tinville becomes a chief prosecutor, accusateur public. In Russia, 1917 is the Russian Revolution. Vyshinsky then works in the provisional government, where he undersigns a ministerial order to arrest Lenin. In 1920, he's a member of the Communist Party and head of the requisition department of the Moscow Railways. 1922, he's president of the College of Lawyers of Moscow. From 1923 to 25, he's chairman of the Collegium of Lawyers, and then a prosecutor in the Judicial Board of the Supreme Court of the RSFSR. 1925 to 28, professor of jurisprudence and rector of Moscow State University. From 1928 to 30, he presided the Shakti trial and the Industrial Party trial. In 1935, he's a member of a special security commission of the Politburo to direct the liquidation of enemies of the people. In 1935, he's Procurator General of the USSR, and from 1936 to 38, he's public prosecutor in the Moscow trials. In Germany, in 1925, Freisler joins the Nazi Party and defends its members in court. In 1933, Hitler is appointed Chancellor by Hindenburg, and Freisler is appointed as department head in the Prussian Ministry of Justice. In 1934, he becomes Secretary of State to the Reich Ministry of Justice. In January 1942, he takes part to the Wannsee Conference. In August 1942, he is appointed President of the People's Court, Volksgerichtshof. Their strength: technical knowledge, hard work, intelligence of situations and of other actors and themselves, cultivation of their own reputation, manifestations of humanity or a semblance thereof. Their weaknesses: a lack of emotivity, objectification of future victims, absurd abstraction or ideological discourse, association with the old order or vanquished competitors, and even some cases cognitive challenges, for example, the possibility of alcoholism for Vyshinsky. They are also ambivalent people. Some of their weaknesses, and in particular association with the old order or vanquished competitors, made them easy targets for the new patrons. For example, Fouquier's association with Desmoulins and Danton, Vyshinsky's association with the socialist revolutionaries, and Freisler's possible association with Bolsheviks in prisoner camp. So they were part of the second circle, but never the first. Instruments of judicial terror, the context. In France, the Republic is under threat both inside and outside. In Russia, the country, after the loss of the First World War, is under civil war and is experimenting atrocious famines, for example, from 1918 to 21 and in 1931. In Germany, the loss of the war in 1918 has brought a lot of land losses and a lot of anger. The Treaty of Versailles has established the Weimar Republic, but the Reichstag fire in 1933 puts an end to the Weimar Republic. The tools of judicial terror, terrorist law. We will see now the legal means used by the three dictatorships to consolidate their power, or terrorist law as an instrument of judicial terror. The consolidation of power by the sovereignty of the ruler, the criminalization of difference or divergence, the annihilation of legal protections, the intimidation of the population, the annihilation of political and racial enemies. You will notice the ever-enlarging scope and reach of the terrorization. Consolidation of power is the sovereignty of the ruler. The devil's advocate is unconditionally committed to his patron, the ruler. The ruler is most often an individual, such as Stalin for Wyszynski or Hitler for Freisler, but can also be a concept, like the people or Comrade Stalin or the Führer as the guardian of justice. The French revolutionaries and the Nazis did not rule for long. General rules of law were not changed. The Bolsheviks eradicated the legal system to replace it by a socialist order. Legality is a notion strongly disputed among the Bolsheviks in 4 phases: anarchy and suppression of the legal system and judiciary, the new economic policy and local autonomy, legal nihilism, and socialist legality under Wyszynski. The dictatorship of the proletariat is authority unlimited by any statutes whatever. But the dictatorship of the proletariat, creating its own laws, makes use of them, demands that they be observed, and punishes breaches of them. A plethora of laws, decrees, and orders, for example, in France, La Loi des Suspects, the law of suspects; in the Soviet Union, the Criminal Code of 1922, or the law of December 1st, 1934. And in Germany, the law for the restoration of the professional civil service of 1933, and the laws of Nuremberg 1935, in which we have the law for the protection of German blood and German honor. Revolutionaries, Bolsheviks, and Nazis share a methodology concerning the social and then physical elimination of any real or perceived opposition. Entire categories of people are defined as enemies to be targeted. Notice the common targets. In social groups, the noblemen, farmer, merchants, managers, economic saboteurs, or petty thieves, people without means of existence. In the national groups, the Vendéens, Jews, Poles, Chinese, Gypsies, etc. Among the political enemies, the partisan of Lafayette, the Trotskyists, the Zinovievists, or the communists, and the supporters of foreign powers. In Russia and Germany, the official legal framework is completed by a secret one, through indirect reference to party directives, political decisions, specific constitutions of the repressive institutions in charge. The law courts are also involved in the exclusion of enemies by the annihilation of legal protections. For example, in Germany, they annul the contracts or the personal status on the principle that every law must be understood as containing the unwritten proviso that, open quote, Jews should receive no advantages, end quote. An example, the case of Ufa versus Charel. The 3 devil's advocates play very important roles in those activities by creating and enforcing laws and decrees as prosecutor or judge. For example, Wyszynski by using his position as Procurator General of the USSR to interpret the criminal code, as is exemplified by his letter of 7 July 1937, decreeing that all hooliganism having contra-revolutionary or chauvinistic motives is classified as a political crime under paragraph 5810, anti-Soviet and counter-revolutionary propaganda or agitation, or 59.7, provoking national hatred of the Soviet criminal code. Now, one example of the crimes they prosecuted or created: wrecking. A letter from Chief Prosecutor Wyszynski to Stalin in January 1938. I inform you that the Prosecutor's Office of the Leningrad region has completed its examination of the case concerning the trolleybus accident that occurred on December 26 in Leningrad. The investigation showed the existence in the trolleybus park of the city of Leningrad of a group of saboteurs. This group aimed to cause accidents and ruin the city's public transport. The accident that occurred on December 26 is also the result of the activity of this group. While the trolleybus was traveling on the Fontanka quay, the tire on the right front wheel burst. Driver Baikov jumped out of the vehicle, leaving it uncontrolled, as a result of which the trolleybus fell into the canal. 13 of the 50 passengers died. I propose to take this case behind closed doors before the military court of the Leningrad region, condemn all participants to the death penalty, Baikov to 10 years. Have a short article published in the press. I ask for your instructions, Vyshinsky. In red pencil, Stalin scribbles on the letter, qualified Baikov at 58.7. Article 58.7 of the Criminal Code of Russia, undermining the state, transport with counter-revolutionary purpose, death, confiscation of property, and loss of citizenship. In the three countries, we have both a form of state terrorism aiming at rational instrumentalization of violence, its premeditated and calculated use, including its intensity, to create a governing system based on arbitrariness and fear imposed to the whole social body, and a system of terrorist overbidding operated by some actors to dominate their enemies in a permanent power competition. For example, in the case of state terrorism, the massacre of Vendée, Nantes, Lyon, the Wannsee Conference and Action T4, the NKVD orders, and as a system of overbidding, the trials of Girondin and Danton, the elimination of Rome and the Essay, and the Moscow trials. In the case of Soviet laws in particular, the Soviet regime uses parajudicial and administrative procedures to eliminate its enemies. Parajudicial, such as the factory show trials. Administrative, like the NKVD secret orders for mass operations and national operations. A few examples of the mass operations and the national operations of the NKVD. NKVD Order 447 about the repression of former kulaks, criminals, and other anti-Soviet elements of July 1937, under which 386,000 people are sentenced to death and shot. Order 486 on traitor of motherland family members of August 1937, which send the wives to the Gulag and the children to orphanages of the state. National operations, NKVD Order 485 on the liquidation of the Polish diversionist and espionage groups and POW units of August 1937, under which 111,000 are sentenced to death and shot. You also have the Harbin operation, the German operation, the Greek operation, the Latvian operation, the Korean operation, the Romanian operation, the Estonian operation, the Finnish operation. All those operations will end on November 17, 1938. NKVD orders establish regional quotas of targeted victims to be shot, first category, or deported to the Gulag, second category. Quotas are filled in two ways, either lists of isolated individuals which are obtained, for example, by relational chains of suspects like family or nationality, or by torturing individuals who are more likely to confess under torture, like fathers. They can be filled also by grouped cases of past counter-revolutionaries, spies, or terrorists forced into confessing. The files, which are called protocols, are a few lines, like the one on the right of the screen, and sent into binders to the troikas and dvoikas, or to the Politburo to be decided in absentia. In the result, 800,000 people are executed in secret. Vyshinsky plays an important role in the enforcement of NKVD orders, for example, by his letter stating that the executions of an imprisonment under Order 447 do not require confirmation from any judicial body of 7 August 1937. Example of Nazi laws, the Wannsee Conference of January 1942. Freisler is a delegate of the Justice Department to the Wannsee Conference, which establishes the administrative framework of the Holocaust. Nazi and Soviet repressive laws and decrees share some characteristics. They are often retroactive, they apply to crimes of omission, they impose extreme sanctions, often the death penalty, and they are written in general terms which allow the repressive courts to extend jurisdiction and impose more brutal sentences by analogy. Terrorist laws are enforced by exceptional jurisdictions, which are developed in three ways, not necessarily exclusive. First, the politicization or elimination of existing jurisdictions. Second, the creation of specialized jurisdictions, which are more and more politicized. And third, the creation of purely political jurisdictions. The revolutionary, Bolshevik, and Nazi regimes developed a plethora of such jurisdictions. They are civilian, for example, the hereditary health courts or the factory courts, criminal, like the special judicial presence of the Volksgerichtshof, military, like the Military Collegium of the USSR Supreme Court, and secret police, like the Dvoika or Troika. The purpose is systemic competition between institutions in order to protect the power of local leaders and the physical security and political dominance of the leader and his henchmen, thus geographic and political competitions. Relationships between secret police organizations and the procurators are essential. They feed each other and work together to eliminate enemies. They are also complex or even brutal. It is a closed circle constantly renewed by political and physical elimination of entire families. Heads of the political police can become procurators, and procurators are also related to political police officials, as in the case of Averbach, who was a procurator and wife of Jagoda, the head of the NKVD. After Jagoda's fall as head of the NKVD, both spouses are shot in 1938. Her mother is sent to the Gulag, and her son to a state orphanage. The tools of judicial terror, terrorist judiciary, fanatical judges and prosecutors. In the three regimes, judges and prosecutors are selected for their fanatical political opinions and not for their legal competence, without any debate. One example, Leonid Zakhovsky, the head of the Troika system. Among the Bolshevik judges and prosecutors, we have the case of Leonid Zakhovsky. In 1917, he was a founding member of the Cheka. He takes part in suppressing the anti-communist rebellions in Astrakhan, Saratov, Kazan, etc. From 1926 to 1938, he is the head of the OGPU in Siberia and Leningrad, head of the Troika system. He denounces his former boss Jagoda for protecting oppositionists in the party, and he writes a guide on torture. He boasts that he would have Karl Marx confess to being an agent of Bismarck. In January 1938, he is first deputy head of the NKVD, where he tortures Jagoda into confessing that he is a terrorist. But in April 1938, his origin as a Latvian and his association with Jagoda place him in the sights of the new boss, Beria, and order number 4990, the Latvian operation. He is sacked, arrested, accused of being a member of the Jagoda conspiracy and organizing a Latvian clique in the NKVD. He is tortured and shot on the 29th of August 1938. The second worst case scenario is the pliant or amateurish judge. In the three countries, we have a similar scenario. One, support of lawyers and judges to the change of regime. Then, distancing between the legal establishment and the revolutionary parties. Then, institutional replacement by control of judicial careers or decisions, such as the obligation for the judges to deliberate and to opine publicly. Then, case-by-case manipulation, as in the Danton case. Then, abandonment of legal practice. For example, in the 1930s, about 160 lawyers in Moscow who have been accused of counter-revolutionary plots are sentenced to death and shot. Then there's repression, opposition, and collaboration, as in the Section Spéciale of the La Cour d'Appel de Paris in 1942. Absent or pliant bars and law professors. In most political jurisdictions, lawyers are selected for their political opinion. Thus, they don't defend their clients, but the system. As an example, Ilya Brode, in the Knyazov case during the trial of the 17, the parallel anti-Soviet Trotsky Center of January 1937. After all, a counsel for the defense, Comrade Judges, is first and foremost a son of his motherland. He is also a citizen of the great Soviet Union, and the feelings of great indignation, wrath, horror, which all our country, both young and old, are now seized with. The feelings which a prosecutor expressed so clearly in his speech, these feelings are inevitably shared by the counsels of the defense as well. I am defending Kniazev, the head of the railway, who, in order to please the Japanese intelligence services, derailed trains carrying workers and Red Army men. Terrorist proceedings. A terror trial in France, the Danton trial, from the 2nd to the 5th of April 1794. It is the liquidation of the indulgence by the enraged and the Robespierrist. He is accused of maintaining relations with royalists or support to the Girondins, preaching clemency and moderation toward the suspects of the terror, enrichment of himself and his friends while he was Minister of Justice. A cascade of procedural and substantive irregularities by the President, Herman, partiality, refusal to call defense witnesses, exclusion of the accused from the verdict and the sentences. Second, by the prosecutor, Fouquier-Tinville, prior screening of the jurors, amalgamation with accused of financial crimes, bankers, for example, absence of material indictment evidence. By the President and the prosecutor, shortening of the hearings, intervention with the jurors while deliberating, obtaining a decree prohibiting public debates and pleadings by the accused. You also have the presence of members of the Committee of General Security who stand behind the jurors. At the end of it, Danton and his co-accused are sentenced to death in absentia and immediately executed. Terror trials in Russia. There were two categories of trials organized by the Bolsheviks in special judicial presences. Economic trials from 1922 to 32 to deflect the public attention from the disastrous economic policies, and political trials, the Moscow trials from 1936 to 38, to eliminate the possible opponents to Stalin's seizure of power, including the top military officers. The economic trials, we have the engineers or Shakti trial, the scientist trial, the industrial party trial, the Menshevik trials. They concern engineers, managers, scientists, and economists who are tried for wrecking the Soviet economy. They are accused of forming invented anti-communist organizations such as the Union of Engineers organizations, and there are many similar trials in the factories. Those trials before special judicial presences are all presided by Vyshinsky. The Moscow trials. We have the trial of the 16, the Anti-Soviet Trotskyist Center, the Parallel Anti-Soviet Trotskyist Center, the trial of the generals, the trial of the 21 anti-Soviet bloc of rightists and Trotskyists between 36 and 38. The trials are ordered and orchestrated by Stalin, who even reviews the official records afterwards. Apart from a few moles, all accused are sentenced to death and executed without appeal. All are prosecuted by Vyshinsky, who constantly refers to Stalin.
Emmanuel, we're slowly running out of time. So
one, the trial.
I'm really sorry because it's fascinating, but
of July 1945. The techniques are theatricality. Soviet trials, including the local and factory trials, are exercises in public education, that is propaganda, framing the accused psychologically and physically to create a new truth, a cognitive aspect of justice. The confessions are obtained by breaking the resistance of the accused, physically, for example, sleep deprivation, walking, psychologically, for example, false promises of leniency, threat against a family, and then forcing him or her to collaborate in the perfect memorization and regurgitation of the script prepared in advance by the NKVD in accordance with its objectives and ideology. The trials are rehearsed with NKVD agents disguised as members of the public or foreign journalists. The accused are tested by being asked if they admit their guilt, and anyone changing his testimony is tortured.
So I guess you're trying to get to the... We can't hear you.
You can find the whole thing on Academia, but it gives you a general idea of the comparison between the three systems. It's incredible, just incredible, the parallels between the French Revolution, the Nazi and the communist regimes. It's fascinating. And the real issue for me is that when I was a refugee judge, I heard a guy who was the Deputy Minister of Justice of the communist regime of Afghanistan. He was doing exactly the same thing, which is being done right now by ISIS, even in the few places which they're still controlling. So there's a lot to be done to understand how these systems function. Thanks.
Thank you very much. I'm really sorry because
No,
it is
it's okay.
I share your fascination, but I think I'd also like to give some. Well, at least the 20 minutes that we have scheduled for the presentations, and then we'd like to have some discussions afterwards, and then maybe we can come back. Hopefully you'll still be able to attend then to some of the ideas you shared. But thanks, really thank you very much for a very fascinating observations, comparative in space and time and law. So I think you did all of them exploring the really dark sides of law. With this, I would like to hand the floor and go back to a bit to the reasoning at least tort lawyers are more accustomed with, while being aware that causation, the concept of causation, causality gives a lot of room as well that could be manipulated in one way or another. But I let you, Bruno, to elaborate on that. Bruno is a researcher in private comparative law at the University degli Studi della Campania, Luigi Vanvitelli. He's also teaching at the Faculty of Economics in Rome. And that will have to do for now, because I'd rather listen to you presenting than me presenting you. Please, the floor is yours.
All right. Thank you very much. Thank you to the chair, first of all, and to the organizer for having me participating in such a prestigious context. I'm very happy to share with you some of my ideas, which are contained in a book I published in the year 2020 and in a paper in English, which I will be happy to share. I don't know if you can see my screen. I hope and I guess you do. If so, if you can see my slides, let's start without any other waste of time. Well, while dealing with causation, proof, and science of the very tricky and complex relationship, a good starting point is that when we describe the way causation is nowadays applied, according to many legal scholars, we can recall the blanket syndrome. When you cover your feet, your neck will be exposed. When you cover your neck, your feet will be exposed. I mean, it is...
Just a moment. Not everyone can see your screen. I can choose between the screens, but I'm not sure I can just... Emmanuel, can you stop sharing your screen?
Yes, maybe Emmanuel has to stop sharing.
I can choose between the two of you, but I only see... And apparently it's only me who sees them.
Now it's okay.
I can see his screen now.
Perfect, thanks.
All right. Without going backwards, I just was saying that to inquire the relationship between causation, proof, and science, a good starting point is the one according to which nowadays it is nearly impossible to elaborate a theory about causation, which is to be applied in any situation. And it is not possible to create a formula which is bonne à tout faire, And this is, I guess, a first dark side of the law, according at least on the scholarship level. And one of the reasons, of course, there are many reasons, I think, is that the dominant model has been, and still is, the famous conditio sine qua non, which corresponds to the Balfour test in common law countries. Of course, there are many other variations, different models. Some of them are mentioned here. And I don't have time to go into them, but the final framework I will propose maybe encompass most of them. And when I talk about the conditio sine qua non to my students, they say, wow, they get enthusiastic. What a powerful tool. I mean, with the mental subtraction process, we imagine that the conduct of the defendant does not take place. And we check if without which that conduct, the damage still occurs to the plaintiff. I mean, it is really charming, but then they very soon discover that to apply the conditio, you must know in advance the link between the conduct and the damage. And in a world which is getting more and more complex from an economical, social, technological, above all, point of view, many of these scientific laws we rely on are probabilistic or stochastic laws. So the condition is really a blunt weapon. And just to give you an example, in a case of late diagnosis of a tumor where 60% of patients would have died anyway and 40 would have survived for a time of 5 years, this is a big problem. How can you tell in which class the patient would have fallen? The lucky one or the unlucky one? Maybe he was under the hands of the best magician ever, but you don't have any tool to tell which is the applicable class. And just I open up a parenthesis and close it out of the blue. There are good writings, very good writings by Harold Luntz, which explain to us that very often we have more than two classes. And then it is very complicated to calculate how probabilities decrease along the time, because we have 40 at time 0. But what about 1 week later, 2 weeks, 6 months? I mean, how do we measure this decrease in the probabilities? And this is probably a gray side, if not a dark side of numbers. The response to that is to be found probably in the very quintessential distinction between general and specific causation. I will not get into Italian law too much, but just as an example, in a very famous decision, a leading case by the joint sessions of our Supreme Court, it was said very clearly that it is not allowed to automatically draw from the probability coefficient expressed by the statistical law the confirmation or not, I would say. I'm not going to inquire what or not means, about the existence of the causal link. And the judge, as a consequence, must verify its validity in the specific case on the basis of the circumstances and the available evidence. And this is a very important tool, but let's consider the dark side of general causation, something I am really keen on discussing with you. Consider the following case. A patient is hospitalized for a bowel infarction. The doctor presents the surgery 4 hours later and the patient dies. Clinical studies show that if the surgery takes place within 2 hours on the onset, the patient has a 30% chance of survival, and the percentage was drawn. This is what emerges during the trial with reference to people over 50. Well, any lawyer would say, well, our patient was a young Olympic champion. The health conditions really do matter. But if the scientific study is reliable, we should say in principle that all the conditions, all the factors which have not been considered do not matter. Otherwise, the study is not reliable itself. And of course, I'm thinking about what Professor Moretot told yesterday, you know, that the trial is retrospective while science is onward looking. I mean, the courtroom cannot turn into a research center if you don't have another study to contradict the fact that the health conditions are not considered by that study. The judge has not any tool to sustain the claim. And even, this is another second important point, even if you find another study, it is very, very likely that the other study only takes to a refinement of the statistical class of reference. Maybe if you consider health conditions, general health conditions, you can say that the percentage is 40 or 50 or whatever, but you don't have any way to apply the percentage in the single case. This is my point. While around the world, courts are full of decisions in which the general causation is turned into a specific causation without a real awareness of understanding of that point. I was reading some days ago, Sydney versus Temolis, a very interesting Australian case. The decrease in the probabilities, again, a late diagnosis case, was from 42 to 38. And the court said, yes, it is clear the plaintiff was falling into that 4% difference gap without any motivation on that. And it is very interesting because then the defendant said, wait a minute. Okay, I will pay, but please let me sentence for loss of chance. So loss of chance became a defense rather than an action. And moving on from this point, in Italy, we have a riot because the Court of Cassation said, all right, we agree on the difference between general and specific causation, but we have to consider that damages resulting from incorrect or late diagnosis can lead to the loss of chances of survival or recovery, which are themselves a protected situation, like a right. And now the picture is very complicated because even chances below 50%, the traditional threshold, are recoverable if they are serious, appraisable, and consistent. And we should open a dialogue with linguistics to understand the real meaning of those words. And if they are annulled by the defendant according to the more likely than not standard. And here a second point. I mean, I really think that loss of chance is pure fiction, a necessary fiction, but a fiction. Because if the doctor does not intervene, with which probability does he annul the chances of the patient? By a probability of 100%. Of course, it is a necessary fiction because here the elements necessary to sustain the claim cannot be proven, and it is no fault at all of the plaintiff. But still, it is a fiction to apply causation under very uncertain circumstances. And it is not coincidence very quickly that in common law countries, we have had very different answers to Locke. It has no citizenship in Mad Mal, according to the House of Lords. Very, very positive on that. It is admitted in the US, in the medical malpractice area only, and only in some jurisdiction, about half. And you can find very contradicting decisions by Supreme Courts of different states. Here you have two decisions quoted, published in the same month, saying exactly the opposite things on a very similar case. It was denied citizenship in Canada, which is very interesting because the decision concerned Quebec, which, as you all know, was very much influenced and still is influenced by the French experience, which was in turn the cradle of chance. And it was still denied in Australia by the Supreme Court, but successive sectorial laws and decisions provided for its recognition. So we have some questions here. It is interesting to consider that in the US legal system or systems, the issue is state law. It is sometimes admitted that the more likely than not standard can be applied in the weak version based on the general causation I was referring to. Little problem, more likely than not leads to full compensation. Loss of chance leads to partial compensation. So here we have again another big contradiction, and so we have to ask ourselves, is the probability implied by the more likely than not other than the one implied by chance? Also reminding that, as I was saying, the former leads to full and the latter to partial compensation. It is a big inconsistency. And if not, how are the probabilities to be defined? And how do they relate to general causation, which is a key issue, I really think? Well, once again, common law is useful and comparison is very much useful to give some answers. It is said that the more likely than not require a qualitative and not quantitative screening, because the fact probability, what the scientific laws say, is other than the belief probability, than the in-time conviction that the judge has about the probability of the credibility of what the plaintiff says. And so at the end of the day, scientific evidence is only an element of that mix, which leads to the conclusion of the court. All good, we could say, and this is a very interesting corollary because this mainstream also leads to label as unsuccessful all the attempt to build a mathematical system to weigh the evidence, which is still very much fascinating. And relating to the first speech, I think that artificial intelligence opens new lines of research on the web of causation assessment, which I will not get into here. But another question as a consequence, the opposite view. This is the mainstream, but the opposite view does ensure that there is a correct understanding of numbers, even if we don't build a system by which, and I agree, a witness is, I don't know, 10 points, a document is 20 points, an expert witness is 40 points, so that at the very end, yes, we have the winner. The more likely than not has been reached or met. Well, to this regard, it is very interesting to note that non-legal literature offers at least 5 meanings of the concept of probability. You can find here in the slide sort of a screenshot. I will not go again into them, but they can be very useful to make internal distinctions, even though tangential distinction between medical, statistical, epidemiological evidence. For example, what if a given disease is attributed by 75% to smoking and the plaintiff is a heavy smoker? Well, a judge could say, clearly we had the more likely than not met. But then it turns out that the same disease is attributed by 57% to alcohol consumption. I mean, how is that possible? The sum is clearly higher than 100%. Well, and the explanation is that using one of the theories about probabilities, that epidemiological studies very often, not always, but very often limit themselves to establishing associations between the variations in the frequency of events in the considered groups without establishing direct causal links. So they do not say how likely it is that a given event is the cause of another, but rather how unlikely it is. And here the understanding of numbers and the same dialogue between the different players in the trial, the lawyers, the expert witness, the judge, is very important. I mean, are we sure that when we use the word probability, they really mean the same things? And before going to the conclusions, after this one, 2 more slides to go, and that's it. The framework I will propose is located in a wider perspective. Before all the discussion I try to offer here, we have to be aware that there can be a big problem if we have conflicting scientific studies or the same scientific law is not completely reliable. I mean, how that phase of the trial in which you have to validate the scientific law, because before basing on it, the general causation claim is completely discussed. I mean, how that turns into the assessment of probabilities, difficult issue to sort out. And the same is when we establish individual causation, but we have what I called vertical causation. Imagine that to sustain the claim, you have to prove for 3 elements. They are probable by 60%. If you multiply the probabilities, then you get mathematically to 21.6%, which is much lower of, the more likely than not in a mathematical sense. And of course, you can say, you're right, I will go step by step on each element. But in this way, you are really kicking out of the trial some uncertainty that surrounds the claim, and maybe loss of chance can be a tool to correct this problem. Getting to my conclusions, some possible solutions. I do think that the typical area of the more likely than not should be limited to cases where a universal law is to be applied. Of course, we do have universal scientific laws. If that were not the case, we couldn't build, I don't know, bridges, buildings, ships, and so on. This is the most coherent application. Then we can make a policy decision, and we say a statistical law close to 100% as the same way as a universal law. And maybe this is, I think, an original proposal. We can make another policy choice. Why don't we apply the more likely than not to establish whether the case of the plaintiff falls under general causation or individual causation? If the plaintiff proves that with a standard of more likely than not, the general scientific law is to be applied to his case, well, we can still say the claim is to be sustained. And as a consequence of that, the typical area of chance is that of general causation, pure general causation, considering what I proposed to construct as an abstract individual chance as a fragment of a concrete collective chance. If we have 10 people, for example, and the total damage is $10,000, but each of them suffered the damage with a 30% probabilities, and we award each of them only 300, it's really like awarding the total damage of 3,000 suffered by 3 people out of 10 to all the 10 members of the class. And in this way, we are actually making a cross-finance between the different positions, which changes nothing in terms of deterrence. If we have a hospital which carries out the kind of treatment, the deterrence will be the same. And of course, many of you will say, well, we should envisage other substantial and or procedural exceptions for policy reasons. I do agree, but I really think on the other count that we need solutions inspired by a keep it simple approach, even though many issues are still unresolved, and take into account that at the end of the day, causation is a vision of the world. I am convinced fully that comparison and other disciplines, so this is a beautiful occasion to speak, have a lot to say about that vision, about the way we build it and we apply it so that some light may be shed on the dark side of numbers. And for 2 little candles, I dare just to suggest my last book and a paper in English, which I will be happy to share with everyone. Thank you very much for your attention.
Thank you very much for your interesting presentations. You brought us back to the area of tort law in the narrow sense, and with a fascinating issue, interdisciplinary and comparative, really inspiring. I'd like to open the floor immediately to anyone who would like to react on any of the presentations. I think time is too short that I can that it's worth me trying to structure the discussion. I think we'll just go ahead in a more brainstorming, interactive fashion. Ignacio.
Thanks to all speakers. Fascinating and enjoyable, entirely enjoyable. One short question to Bruno. The 30% example you made at the end of your presentation makes me think that insurance issues get in the picture as a key to solving those theoretical issues, because in the latter case you mentioned, on insurance terms, the two solutions are perfectly equivalent. Deterrence is insurance premium at the end of the day. So how does insurance fit the picture?
I think that in theory, insurance can be taken into account, especially for the last construction. I mean, if we give 30% to all, and we don't know that in advance, it is much easier to ensure, to find an insurance for that activity. The hospital knows that there is 30% risk. That risk will be compensated to the victims, but at the very same moment, shifted actually to the insurance. And another good effect is the following one. Usually we deal with these issues through class actions, which do have bright sides and dark sides. This is a case of assessing those problems on an individual level, but really reducing the transaction costs. And so, and I finish my answer, in this way, we ensure that judges can take into account the existence of an insurance without doing that in a hidden way. So there are no distortions on the system, because very often the judge, of course, uses his discretion considering the existence or not of a valid insurance.
Are there other questions?
Yes, it's very interesting because we're getting right into embodiment and the cognitive psychology there. And I would like to refer you to a very interesting book, which I'm reading right now, which is The Psychology of Tort Law by Robin Ault and Hans, which deals precisely with those issues of cognitive psychology and how human beings evaluate risk and chances. And what I find very interesting in your process, in your attitude, Bruno, is this opening of the legal system to other ways of thinking. My problem, though, is that the legal establishment, and especially the judiciary, is completely hermetical. How many of our judges have at least a BA in any science? So that is something on which I think we, as Juris Diversitas, could and should work very hard. Establish those bridges, because the technology is changing very quickly. Thank you. It's been really interesting.
Thank you very much. If I can comment on this, really thank you for your remark. In many books I have read about causation, I always find the so-called pars destruens of the analysis. What I try to do is to propose, so to say, pars costrans, and if we do that all together, maybe we can have a project under Juris Diversitas, then it will be easy to educate people to what some author calls legal innumeracy.
Thank you. Asha, you have a question?
No, just a comment, given the lack of time. Thank you all for your wonderful presentations. I have quite a detailed feedback to Emmanuel's presentation, because I'm not a stranger to the topic, given the family history and the research interest, but it's really very long. So I think we should arrange a private meeting, because it is really very detailed. So I will look at your paper. Yes, but I have quite a lot to say, so please come back to me and we can discuss this in more detail, having more time, and you have a less stressful environment around. So, but thanks a lot. So, you know, your research is truly comparative, well documented, very thorough, and very topical and needed given all the recent trends that we are having now in Russia in exonerating the Stalin's regime and justifying the crimes by economic perspectives, etc. But that's something to be discussed in more detail. So thank you.
If I can answer to your comment, Asia, at the end of my presentation, I look at this specific issue and the contrast there is right now in Russia between the work done by a number of people, some individuals, but also associations, versus the official attitude of the government. But there are lots of people who are interested to get into the old regime because they've been profoundly damaged physically and psychologically, personally, or in their families. But there's a lot that is going on.
Yeah, but on both sides, you won't wait long till those official kind of scholarship will reach the international market. And this is why your research is very topical and very timely. Thank you.
Good, we'll be interested to hearing more on your discussions. I just have a last question. I'm abusing of my role, but I would like to ask a question to Livio to bring us back to where we started. And just one observation, you mentioned the role of the central agency and how it was criticized, but you didn't mention what you thought about it. So could you explain what you think whether having such a central agency would make sense or not, especially from a torts perspective?
Well, actually, as any other issues in the matter, the goal is to find the right balance, even in this case, in the case of the central agency. I mean, the central agency must be, the power of the central agency and the characteristics of the features of the central agency must be clearly detected, just to avoid the risk to be too much, I mean, narrow and put in a cage the actors involved in the producing, selling, and using of robotic technologies. This means that European scholars call it the chilling effect of liability law. And it's something that we have to avoid, we need to avoid finally. This is my position. So it's not, I'm not completely contrary to the idea of the central agency, but must be really well defined.
Good, thank you. We'll have to close on that. It will be interesting to hear the impact of positions of such an agency on assessments of causation. So I think we have many strands of discussion between us, and I'm really looking forward, and I hope that we will be developing the discussion. As a bottom line or some closing thoughts, I think the panel showed very well how important interdisciplinarity is. I mean, that's again what Juris Diversitas stands for, in order to grasp with concepts, legal concepts that have been there for ages and that we haven't really come to deal with easily, in order to deal with issues, social issues, technical issues, and political issues. And I think looking beyond the discipline of law, but also looking, as Emmanuel pointed out, looking between the different instances, comparing, I mean, the core of comparing, and trying to use it in a way, Emmanuel, I think you didn't have time to develop that, but trying to use it in a way that for the good, if I say it very easily, for the common good. I think that's one of the challenges that we're facing. With this, I would really like to thank all three of you for your fascinating presentations. It was a pleasure chairing To some extent, it was hard because I had to cut on interesting presentations, on interesting discussions, but I'm convinced that we'll be able to discuss bilaterally, multilaterally, and that we will continue to be dealing with those ideas and topics. Thanks for sharing links, publications. I'm looking forward to reading you and discussing. With that, I wish you all a good evening and see you tomorrow.
Thank you very much.
See you tomorrow. Bye.
Thank you.
Bye-bye.